Welcome back to this third segment of this law session on answering public law exam questions. Now, in the last segment, we did look at a question as it relates to constitutions generally, and I gave you some guidance in respect of that. In this segment, of course, we're going to attack another question, and in this section, we are going to look at a sovereignty question in relation to public law. Now again, I will return to the University of London LLB pass exams, and this time I'm considering question 3 of 2011, and the question there is, with reference to statute and case law, discuss the extent to which the United Kingdom is sovereign in relation to the European Union. Let's do that again. With reference to statute and case law, so there's a direct statement being made there, you're supposed to refer to statute and case law. Discuss the extent, so you need to talk about how far, to which the United Kingdom is sovereign. Somewhere in there you're going to need to define sovereign in relation to the European Union. So that's you breaking down the question. With reference to statute and case law, discuss the extent to which the United Kingdom is sovereign in relation to the European Union. Now, before we go into the question proper, I want to emphasize, again, please look at the question the examiner has asked you. The question did not say, what do you know about parliamentary sovereignty? Because I will take you back to my Jeopardy analogy. If when the examiner picks up your answer paper and it says, parliamentary sovereignty is about the legislative supremacy of parliament, and it goes on and on and on, and parliamentary sovereignty provides that, and A.V. Dicey says this, and you go on and on and on, and then you finish off by saying parliament is supreme and no one can therefore challenge an act of parliament. You've just written a text about parliamentary sovereignty, but you have not answered the question. So the point is, look at the words in the question, because one of the criticisms of the examiner on this question was that candidates tended to completely ignore that whole point about European Union, or briefly mentioned it as a by the way as they trundled along to tell you everything about parliamentary sovereignty. Now, in any question on sovereignty, you must know what the contemporary issues are which affect sovereignty. So you must know what parliamentary sovereignty is. You must have a definition of it. But you must also know that the two biggest impacts on parliamentary sovereignty are the Human Rights Act and EU membership. That question could easily have said to the extent of the HRA, and the focus would have then shifted completely. The point, of course, is that if you're doing this area, you're taking it on board as an area to ensure that you review in order to sit an exam, you must know the impact of certainly the HRA and the EU. So if this is a topic that interests you, that you need to know, then the 2 areas of HRA and EU law are areas you need to get to grips with as well. Again, in answering an essay question, you must look at the question asked by the examiner. So words like with reference to statute and case law, words like discuss, phrases like extent to which, words like sovereign. Now, it says, and this is the major part of what you've got to take on board, it says, in relation to the European Union. So even if you're going to look at, for example, parliamentary sovereignty being affected by, let's say, devolution or the HRA, even if you were going to mention things like that, they can simply be no more than by the way in order to show the examiner your knowledge. Because the idea of an exam is to show the examiner what you know. It is not to tell him what he does know. And there is a difference. So you should not teach the examiner the law. Meaning, You don't need to say to the examiner, when one looks at parliamentary sovereignty, there are certain contemporary issues which affect it. We will, of course, look at these contemporary issues. Human Rights Act. The Human Rights Act certainly has some impact on parliamentary sovereignty because, and you go on for a good 2 paragraphs on a Human Rights Act. That's irrelevant. However, if you were to say, for example, that when one considers the extent to which the UK sovereignty has been impacted in relation to the EU, this, of course, is one area. The others, of course, have been, for example, the HRA, which has impacted how judges deal with legislation, and certainly devolution, i.e., certain powers being devolved. That said, however, the primary focus here will be the EU. Now, the point about that is, yes, you can show, by the way, that you know a little bit about the impact of the HRA and devolution, but that doesn't mean that that forms the substance of your answer. Substance of your answer is going to be the focus on EU. So it is not just a question here in relation to parliamentary sovereignty generally. It has a specific focus. Again, you may want to start with definitions or paths. A good starting point is to explain the concept, the principle of parliamentary sovereignty. So, you could briefly discuss the difference between legal sovereignty and political sovereignty before then moving on to focus on legal sovereignty, which is what we generally discuss at large. Now, given your under-exam conditions, the best course, of course, would likely to be that you adopt A.V. Dice's 3-part explanation. You can't start getting too fancy because, of course, the difficulty is you may very well fail in your time management. So, simply adopt A.V. Dice's 3-part explanation. You should then, of course, turn your attention to the European Union with, of course, a brief explanation of its origins and how it has evolved and, of course, its impact. Now, because the question says that you should consider reference to statute and case law, this would require you to explain the major cases which, of course, have been decided by the European Courts of Justice on the issue of sovereignty, and certainly also the major cases on the subject as well, which, of course, have been considered by the domestic courts. Now, in relation to the European case law, you could, of course, have looked at and included cases like Castronino, Van Gendenloos. You simply cannot do any question on EU law without mentioning Van Gendenloos and Netherlands. Equally, Internationale and Simmental. Now, when you look at these EU cases, you then may want to briefly discuss the concept of, for example, direct effect and indirect effect. And you can see how the courts have, the ECJ or the Court of Justice of the EU has put this into practice. You may also want to consider cases like Frankovic and state liability. Again, you use the law carefully and you do it in a way which shows that you've grasped it, and so you are able to put it on paper with ease. Now, looking from the standpoint of the cases coming out of the domestic situation, you could, of course, consider cases as well as the legislation. Now, again, no discussion on EU law in relation to the UK can be complete without mentioning the ECA 1972, the European Communities Act. So you would have had to have discussed that, and certainly Section 2, very important to explain how it operates, as it is the conduit through which EU law comes in and becomes effective within domestic UK law. So in your writing, a good start may seek to ensure that the question statements are taken account of. So for example, if I was starting and I was writing this, I would maybe start along the lines of, in determining the extent to which the UK is sovereign when considered in the context of the European Union, it appears clear from the case law that some degree of sovereignty has been abrogated. The relevant statute appears to suggest that primacy has been given to EU law, and this, of course, will be examined in respect of the statement. That would be my start. I have pulled on words in the question. Now, in the next paragraph, a definition of sovereignty would possibly be needed, and possibly the first indication of the EU's impact by virtue of the ECA 1972. Now, the danger for this type of question is discussing parliamentary sovereignty while completely ignoring the part that talks about the impact of the European Union. This, of course, would show a failure to read and interpret the question properly and with care. Again, this is a question where if you were then moving on into the second paragraph, for example, or third, as the case may be, you would define parliamentary sovereignty, and then again, by about paragraph 3 or 4, you start nailing down exactly what the impact is and looking at, as I say, the various cases and dealing with them, and then at the end, coming to a conclusion which reflects your discussion, pulling it all together in no more than, say, a couple of sentences. One of my challenges that I like to give to students is to say, try to write a conclusion without saying in conclusion. Because the vast majority of times when students are writing, they just think, oh my goodness, I need to stop now. So it's not so much a natural conclusion as it is a stop, a severe stop. And then they put in conclusion, just to let the examiner know that, by the way, if you're going to come up on this stop as well, I want you to know that I've finished. Try and doing something along the lines of, in all the circumstances, based on the wealth of argument or the breadth of the arguments in favor of, or given the strength of the argument as it relates to, or overall, therefore, try and challenge yourselves by writing a conclusion that doesn't say in conclusion. It might be interesting. Again, I will say to you, if you are signed up to our premium service, then I would suggest you contact us to request a copy of a sample answer to this question, which I've just gone through, which I have certainly personally written under time conditions of 35 minutes or less. After the break, we will of course consider our last question, and it is a question on the Human Rights Act, immediately after this break.